afternoon. I'm going to begin. Fred Logue was due to speak, I think, 15 minutes ago, and he seems to have bowed out. And there's no third lawyer. I think originally there was going to be a third lawyer, so I'm the only lawyer you have to deal with today. My name is Brendan Guildea. I'm based in Dublin, but like all of my colleagues in the law library, more than willing to travel if the price is right. Quite possibly, this topic, the sustainability race, I think it's implied, but it's the race against climate change, so possibly that should have been a bit more explicit in the programme. And my goal for this talk is to eventually to build up to this slide, which you'll see later on in the presentation. Okay, and what I've done is I've taken the projections from the Sea Road simulator. I don't know if many of you are familiar with that. And I've taken the CO2 parts per million on the left and the global temperature increase on the right. And as you can see, and I'm sure as everyone here knows, these are increasing, but the rate at which they are increasing is also increasing. Okay? And myself, in a fairly crude manner, I've just put in 3 events or 3 points, which I will come back to. And I think any international treaty on patentable technologies, I think, should be laxed or relaxed once these events have reached. And I'm sure we'll all agree that it might be in the benefit generally of the world for that to happen. Okay, but first, patent law. Okay, so I have to build into it. Hands up if you would describe yourself as being familiar with patent law. Nobody here. Okay. So you've chosen maybe hopefully a good talk. So it's a creation of statute. So it's a governmental and I suppose granted monopoly for a limited period, usually approximately 20 years, in relation to the production and use of an innovative and industrial applicable invention. Okay, so you talk about your Tesla car, pharmaceuticals, and any sustainable, I suppose in terms of farming, anything that improves your yield, any of those creators will be looking for a patent. Okay? Now, what I've added here to the usual definition you'll find online is the in exchange. And I've underlined 3 points here. So in exchange for the monopoly, the inventor has to disclose how the invention works. It's a quid pro quo. So they have to disclose how it works and how you can make it work, okay? And that's the exchange. Now, the idea with that is that once the patent expires, everybody else has the right to use and do whatever you want with the patented matter. The patent has elapsed or expired. However, there is also an idea in patent law that during the life of the patent, experiments can be conducted on the patented subject matter. And in the sustainability race and in the technology race to get more green, more efficient, the inventors are all trying to outdo one another. But there's a real limit under patent law to what extent this is permissible. And that's what I'm going to cover now. This is the language in Ireland that we have this experimental use exemption for patent law. So generally, if you're conducting experiment, you can do it. But there's 11 words here underlined. It's only limited to experimental purposes relating to the subject matter of the relevant patented invention. And my goodness, as a lawyer, you're very delighted to see these 11 words because it complicates it. And the experimental use defense is very much limited. It is, I suppose, it depends on the circumstances and what is the purpose of the experiment, okay? And I've just put in the relevant European development. It's not just the folly of our own we're embarked upon. It's actually a fairly standard global portion of patent law, so it would be the same provision everywhere else in the world. And this is the problem, okay? This is the problem that I really want to focus in on, is that usually you have this induction to research, to do research so that a patent will be granted and so that you'll get the money back for the investment you've made in the research. However, as you can see where the red cross is, the experimental use defense really breaks this cycle. So I'm just going to explain now the cycle. So we start here. Patent law encourages people to disclose their inventions, like I said earlier, because they get a monopoly. That's great. As a result of that, sustainable technologies are available. Now, they're available at a price, but they're available, and then there are wide benefits of that. As a result of that, then, you have companies investing in their R&D departments, and you will generally have knowledge transfer cross-border, and that is all well and good. This is where it starts to get a bit tricky. If an R&D department in a competing firm come up with something better that doesn't actually incorporate your invention, it's just an entirely new matter, a patent will be granted. How do they get to this point? Invariably, it's through experimenting on your patent. And so there you have this big X where there's a fear. There's a fear that the technology will be reverse engineered, and that breaks the cycle, okay? So when you're talking about it and thinking about it, is patent law good for research? Yes, it is. But it comes at a price to, we say, how accessible the products are, okay, in terms of cost and any royalties you have to pay. Okay, and probably in the last 30 years, William Cornish in the UK is, I'd say, the world expert on just commenting on this sort of stuff. And he has, I suppose, what I've just described there, he has kind of the two ideas here. So if ordinary people can engage in such experiments as they please, the incentive of the patent may be diminished. So we might see a decrease in the investment in R&D in terms of sustainable technologies insofar as they're concerned. So that's the top one. However, having said that, you don't want inventors, you don't want the monopoly of a patent, which is very specific. You don't want that stifling development generally. So he says here the inventor should not be permitted to use his patent as a check on further experimentation. So there's a balance, okay? Balance to be struck here. And this brings us to the subject matter of this conference. We have solar panels and renewable energies. Those technologies we hope are getting better and better, and also the technologies involved in the reduction of CO2 from the atmosphere. We have the Tesla car here. I'm quite impressed at the amount of hardware we see at this conference from the manufacturing side, and again with the smart technologies, that is all getting a little bit more cost effective and also possibly more environmentally friendly. So, and I've contrasted here, we have the money. Where do we get the money for these inventions? Well, we get them from the inducement, this patent law idea, the system. But then we have good old Fagin there from Oliver, the musical, who's trying to pick your pocket, essentially trying to reverse engineer your idea, get a patent, and then he has all the money. He has all the benefit, theoretically, of your research. Okay, now, I could go talk for hours on the experimental use of defense. I've chosen this one case. It's a touchdown case. It's actually from the 80s, mid-80s. And it's where the creators of Roundup, and this is a herbicide used to kill pests. Now, I'm not sure, I don't want to do a survey on who in this room thinks that herbicides are good for the environment or whether or not they are sustainable. That's a debate for another day. But the active ingredient that was called geophosphate, okay? And they got a patent for that, and that was fine. Let's say their investment in developing that product was I suppose, recouped, theoretically, in the life of the term. But the competitor, Touchdown, essentially got geophosphate, and what they did was they made a compound, a derivative compound from that. So they took their active ingredient, and I don't know if we can get rid of that. They took their active ingredient and they released Touchdown. And this is the difficulty. The owners of Touchdown were saying, well, we want to be able to use it, we've come up with this ourselves, we don't want patent law infringing on what we're doing, and that's fine. That's not actually, once they spoke to their lawyers, the Touchdown people was told them, you can't do that. But then they were saying, well, what if we own a plot of land near our research and development facility? Can we use it there And can we see if the touchdown derivative, if it works all year round, if it just works in the summer. And that was considered an experimental use on their property, and it was a research farm, a specific farm set up for conducting that. And we all in this room might think, okay, that's fair enough. But then the touchdown people got a little bit more creative, and they said, well, we know it works in this kind of biosphere, but we want to see if 100, 200 miles away, maybe a different kind of soil, will it work there? And of course, they found a farmer who was willing to try this herbicide, and he was trying it. Is that an experimental use? And also if, you know, the whole idea of, by accident, if we spray this one field and the wind is blowing a certain direction, an adjoining field might get a benefit, and you might have an adjoining farmer saying, goodness, well, when the wind is blowing this direction, can you do the spray and I will pay you? So you have all these ways of going around the patent protection. And then the difficulty became, well, the regulator for herbicides at the time, in the 80s, they required a certain amount of use, demonstrably beneficial use of the product before they approved it for sale. And so the Roundup guys then figured out, they said, hold on a second, you say it's experimental use, but actually what you're doing is you're building up your use of your product so that you can get regulatory approval. And unfortunately, on that particular case, that was the line that was drawn. If you have a product that is derived from or contains a previous patent, you can't use that product just so you can get regulatory approval. And this would be relevant for our travel industry, our farming industry. All of the sustainable technologies will have an element of, well, goodness, we need approval from somewhere. And absolutely, the law worldwide at the minute is the experimental use defence does not permit so-called experiments which are done for the purposes of getting regulatory approval. So it is a very limited exemption. Okay, and in the 90s there was a big debate about all types of, well, how we can make it better, how we can make the experimental use defence better here. Just of course determining how the patent invention works is fine. Academic and instructional experimentation should be fine. Now in the 90s, the US reports that, goodness, well, it should be clarified. In a situation nearly 30 years later where there is no clarification really, it's only the legal decisions that have issued in relation to the matter come up with these the list of permitted and non-permitted experiments, and this is where the lawyers benefit. If you have a technology which you think might incorporate something in a patent, you will have to get legal advice, or you should get legal advice on whether or not you can benefit from the experimental use defence. And now I'm building back to my first slide. At the minute, let's say Kyoto and the Paris Agreement, they all focus on emissions and reduction. Okay, what are the rates? I suppose the demonstrably man contribution to CO2 in the atmosphere. Okay, and I think we can do a bit better than that. And this is where we go back to our slides. So I suppose my proposal is that I have 3 events, like I said earlier, A, B, and C, and they approximately happen 2026, 2035, and just in the 40s, okay, in the future. So that's how many years? 20 years down the line. And I have the relevant, so the increase in parts per million is 30, 60, and 90, an increase in CO2 in the atmosphere, and then the corresponding increase in global temperature. Now, when you're looking at this, you have to bear in mind that in 1880, when records began, that's over here, CO2 was around 290, okay? And between 1880 and the year 2000, global temperature went up 0.8 of a degree. Okay, so we're now looking at a more severe increase. And, well, so what? Well, what I'm coming up with here is an idea is that once these levels, the CO2 levels, are reached, once the global temperature is reached, whichever comes first, famous lawyer talk, is that you will have compulsory licenses, so that if you're a patent holder, you must permit Now you can get a royalty. You must permit the use of your experiment if it's improved by somebody else. But what I'd say, it should be a nominal fee, and it should be calculated from the GDP. And this will I suppose, will be available in Africa and other developing world continents, less well off, not non-Western world countries. Scenario B then is that we have to look at broadening the experimental use defence by permitting experiments done to develop technology for STEM and climate change. I think there should be an absolute increase in the exemption. So we have paediatric extensions, or I suppose if you're developing something to I suppose assist in the birth of children, that is completely unrelated. But the experimental use defence is a very good way, it's a slick way of just broadening it and permitting the development of sustainable technologies. And then C there, and I'll just click back to C. So once we have over 500, just close to 500 parts per million of CO2 in the atmosphere, which I think is fairly significant, at that point then you will have a situation where patent law worldwide essentially lapses, all patents become fair game, and that would include lis pendens, so any litigation that's going on, all bets would be off then. And I suppose this is the proposal I'm looking at. Again, from how are we doing in time, Ger? 1 minute left. Okay, so Heisenberg here, again writing in the late 80s, and it's amazing how we still really haven't cottoned on to how important this stuff is. So she has 2 quotes there. The idea that exclusive rights in new knowledge, that's the patent system, will promote scientific progress is counterintuitive to many observers of research science who believe that science advances most rapidly when community enjoys free access. Okay, well, we go back to then again to where do you get your funding for your research? That's the big problem. The second paragraph then, but as the line between basic and applied research becomes blurred in certain fields, and this is why I was talking about experiments or activities done to get regulatory approval, patent protection increasingly threatens to encroach on the domain of research science. Okay, and I finished. I suppose there's possibility there on the left of kind of a Wild West scenario where everybody can just steal everybody else's technologies and there won't be any consequences, and that might be one way we go. And then the late John Hurt there from 1984 is possibly an unfortunate spin on what we're seeing now with the patent situation. Is, well, it's the people who own the stakeholders are essentially prohibiting the development of sustainable technologies, and that is kind of a slightly an Orwellian idea that the people who hold the money, the people who, if and when things go south, they will be the people who will definitely be okay, but whereas for everybody else, like for John Hurt's character in 1984, they won't be so well off. Okay, I'm Guildea at Law.